of Peru, and now will deliver a statement in my capacity as the representative of the Russian Federation. Our delegation abstained during the vote on this resolution, as was the case for the resolution on similar topic in 2016. At that point, we voiced grave concerns vis-à-vis the reappointment of the same appointed individuals from the unfortunately, lamentably well-known International Criminal Tribunal in the former Yugoslavia. Today, our fears around these staffing decisions have been justified. The latest two-year round of the work of the residual mechanism is drawing to an end, and the situation in that body is far from cloudless. There are issues in approaches to justice and in issues of domestic internal administration and staffing policies. During the 6th June Security Council meeting, our delegation voiced our assessments on this count. We will not repeat ourselves. At the same time, we wish to draw the Council's attention to one important issue. This is a matter of a right to life, providing defendants with timely and appropriate medical assistance. We have repeatedly called upon the ICTY to conduct a qualitative investigation and treatment into Ratko Mladic, for Ratko Mladic. And if this was not within the possibility if this was not possible for the tribunal's judges to, in a timely manner, release him for treatment in Russia, with us providing exhaustive guarantees. Unfortunately, the tribunal, time after time, refused to allow advocates of the defendant to meet this request. Also, Serbia's requests were denied. The most recent application and request for the timely release of the general was denied by the mechanism on 8 June. When considering the material around the Mladic case, which is openly accessible on the mechanism's website, there is some interesting information that surfaces from the documents of the registrar of the mechanism. Focusing on the report of the independent medical experts, one can draw the conclusion that Mr. Mladic is fearful of the doctors of the United Nations detention unit and does not wish to comply with their prescribed course of treatment. At the same time, lawyers are denied access to be present during the Mladic's treatment during his visits and meetings with the doctors of the tribunal, despite the desire of the defendant for this to take place. The pretext has been fabricated, that being medical ethics. What kind of medical ethics can there be based on trust between a doctor and a patient? What kind of ethics can we speak of if, according to lawyers, the medical service of the mechanism hides part of the electrocardiograms of Mr. Mladic, effectively trumping up this information and hiding it? At the same time, even that medical information that the administration was unable to conceal enabled the defense to draw conclusions about the fact that for 3 months, the state of the defendant has seriously deteriorated. He has not been receiving adequate treatment, and the authorities of the United Nations unit do everything possible to cover up for themselves and to conceal their incompetence. In this connection, a question arises. The information about are the judges receiving information about the state of health of the defendant in the same redacted version? The struggle of Mr. Mladic's lawyers with the penitentiary, with the United Nations unit vis-a-vis the state of his health has been protracted and ongoing for a number of months already. All of the petitions of the defense, time after time, have been denied by the appeals chamber and the president. It has gone so far as to reach an application to disqualify the judge for reasons of bias. In this connection, I wish to put a question to the leadership of the mechanism. Is it aware of what this scandalous situation might cause? I resume my function as President of the Council